पूर्णम भगवती वासुदेव। चैप्टर 6 द कंपनीज एक्ट 2013 लर्निंग आउटकम्स। आफ्टर स्टडिंग दिस चैप्टर you would be able to understand company form of business organizations and its features, corporate BL theory, classes of companies under the Companies Act, registration of companies, memorandum of association and article of association. Company incorporated under the Companies Act 2013. Features: separate legal entity, perpetual succession, limited liability, artificial judicial person. Corporate BL theory: company is different from its members. BL can be lifted to disregard separate legal entity. Incorporation of company: register company with ROC, get certificate of incorporation. For easy filling, follow SPICE plus SPICE. Share capital: nominal share capital, issued share capital, subscribed share capital, called up share capital, paid up share capital. Shares: equity shares and preference shares with uniform rights with differential voting rights. MOA, Memorandum of Association, defines object and scope of work of company. Company cannot go beyond the scope defined. Article of Association defines rules, regulations or bylaws of company. Company has power to alter it. Article of Association through special resolution. Introduction. The Companies Act 2013 was enacted to consolidate and amend the law relating to the companies. The Companies Act 2013 was preceded by the Companies Act 1956 due to changes in the national and international economic environment and to facilitate expansion and growth for our economy. The central government decided to replace the Companies Act 1956 with a new legislation. The Companies Act 2013 contains 470 sections and 7 schedules. The entire act has been divided into 29 chapters. A substantial part of this act is in the form of companies rules. The Companies Act 2013 aims to improve corporate governance, simplify regulations, strengthen the interests of majority investors, and for the first time legislates the rule of blowers and provisions relating to class action suit. Thus, this enhancement seeks to make our corporate regulations more contemporary. Applicability of the Companies Act 2013. The provisions of The Act shall apply to companies incorporated under this Act or under any previous company law. Insurance company, except where the provision of the said Act are inconsistent with the provisions of the Insurance Act 1938 or the IRDA Act 1999. Banking companies, except where the provisions of the said Act are inconsistent with the provisions of the Banking Regulation Act 1949. Company engaged in the generation or supply of electricity, except where the provisions of the above Act are inconsistent with the provisions of the Electricity Act 2003. Any other company governed by any special act for the time being in force. Such a body corporate which are incorporated by any act for time being in force has and has the central government may be notification specify in this behalf. Company meaning and its features. Meaning, according to Chief Justice Marshall, a corporation is artificial being, invisible, intangible, existing only in contemplation of law, being a mere creation of law. It possesses only those properties which the charter of its creation confers upon it, either expressly or has incidental to its very existence. In other words, of Professor Henning, a company is an incorporation association which is an artificial person created by law, having a separate entity with a perpetual succession and a common seal. This definition sums the means as well as features of a company sufficiently. However, the Act defines the term company a bit differently. Section 2, subsection 20 of the Companies Act 2013 defines the term company. Company means a company incorporated under this Act or under any previous company law. As we shall progress under the chapter, the meaning of the term company will be understood by the students. Features of a company: separate legal entity, legal separate from the members, perpetual succession, change in members does not affect existence of company, limited liability. Liability of company is different from liability of members. Artificial judicial person. Company can act through human agency only. Company can contract, sue and be sued in its own name. We have we have seen the definition given to company form from a layman's point of view, a legal point of view, but the company form of organization has certain distinctive features of features that help us to understand the realms of a company. Following are the main features. Separate legal entity. There are distinctive features between different forms of organizations, and the most striking features in the company form of organizations vis-a-vis the other forms of business organizations is that it acquires a unique character of being a separate legal entity. In other words, when a company is registered, it is clothed with a legal personality. It comes to have almost the same rights and powers as a human being. It, its existence is distinct and separate from that of its members. A company can own property, can own property, have bank account, raise loans, incur liabilities, and enter into contracts. It is at law a person which is different from the subscribers to the memorandum of association. Its personality is distinct and separate from the personality of those who compose it. Even members can contract with company, acquire right against it, or incur liability to it for the debts of the company. Only its creditors can sue it and not its members. A company is capable of owning, enjoying, and disposing of property in its own name. Although the capital and assets are contributed by the shareholders, the company becomes the owner of its capital and assets. The shareholders are not the private or joint owners of the company's property. A member does not even have an insurable interest in the property of the company. The leading case on this point is of Mercura versus Northern Assurance Co Limited 1925. Fact in the case: Mercura was holder of nearly all except one shares all shares of a timber company. He was also a major creditor of the company and insured the company's timber in his own name. The timber was lost in a fire. M claimed insurance compensation. Held the insurance company was not liable to him, as no shareholder has any right to any item of property owned by the company, for he has no legal or equitable interest in them. Hence, in this case, since the timber was insured in the company's name, M could not claim the compensation from insurance company. Perpetual succession. Members may die or change, but the company goes on till it is bound up on the grounds specified by the Act. The shares of the company may change hands infinitely, but that does not affect the existence of the company, since a company is an artificial person created by law. Law alone can bring an end to its life. Its existence is not affected by the death or insolvency of its members. Many companies in India are in existence of over 100 years. This is possible only due to the fact that the company has perpetual existence. There was a company which has 7 members and all of them died in an aircraft. Despite these, the company still exists. Unlike partnership form of business, limited liability. The liability of a member depends upon the kind of company of which he is a member. We know that company is a separate legal entity which is distinct from its members. Thus, in this case, in the case of a limited liability company, the debts of the company in totally do not become the debts of the shareholders. The liability of the members of the company is limited to the extent of the nominal value of shares held by them. In no in no case can the shareholders be asked to pay anything more than the unpaid value of their shares. In the case of a company limited by guarantee, the members are liable only to the extent of the amount guaranteed by them, and that too only when the company goes into liquidation. However, if it is an unlimited company, the company of its members is unlimited as well. Artificial legal person. A company is an artificial person as it is created by a process other than natural birth. It is legal or judicial as it is created by law. It is a person since it is clothed with all the rights of an individual. Further, the company being a separate legal entity can own property, have banking account, raise loans, incur liabilities and enter into contracts. Even members can contract with company, acquire right against it or incur liability to it. It can sue and be sued in its own name. It can do everything which any natural person can do except be sent to jail, to an oath, marry or practice a learned profession. Hence, it is a legal person in its own sense. As the company is an artificial person, it can act only through some human agency with directors. The directors can control affairs of the company and act as its agency, but they are not the agents of the members of the company. The directors can either on their own or through the common seal of the company, can authentic- authenticate its formal acts. Thus, a company is called an artificial legal person. Common seal. A company being an artificial person is not based on with a body of a natural being. Therefore, it works through the agency of human beings. Common seal is the official signature of a company, which is affixed by the officers and employees of the company on its every document. The common seal is a seal used by a corporation as the symbol of its incorporation. The Companies Amended Act 2015 has made the common seal optional by omitting the words and a common seal from Section 9 so as to provide an alternative mode of authorization for companies who opt not to have a common seal. Rationale for this amendment is that common seal is seen as a relic of medieval times. Even in the UK, common seal has been made optional since 2006. This amendment provides that the documents which need to be authenticated by a common seal will be required to be so done only if the company opts to have a common seal. In case a company does not have a common seal, the authorization shall be made by two directors or by a director and the company secretary wherever the company has appointed a company secretary. Corporate VL theory. Corporate VL refers to a legal concept whereby the company is defined separately from the members of the company. The term corporate VL refers to the concept that members of a company are shielded from liability connected to the company's actions. If the company incurs any debts or contravenes any laws, the corporate VL concept implies that members should not be liable for those errors. In other words, they enjoy corporate insulation. Thus, the shareholders are protected from the acts of the company. The Solomon versus Solomon and Co. Limited laid down the foundation of the concept of corporate VL or independent corporate personality. In Solomon versus Solomon and Co. Limited, the House of Lords laid down that a company is a person distinct and separate from its members. In this case, one Solomon incorporated a company named Solomon and Co. Limited with 7 subscribers consisting of himself, his wife, 4 sons and 1 daughter. The company took over the personal business assets of Solomon for €38,782 and in turn Solomon took 20,000 shares of £1 each, debentures worth £10,000 of the company with change on the company's assets and the balance in cash. His wife, his daughter and 4 sons took up £1 share each. Subsequently, the company went into liquidation due to general trade depression. The unrescued creditors to the tune of £7,000 contended that Solomon could not be treated as a secured creditor of the company in respect of the debentures held by him, as he was the managing director of one-man company, which was not different from Solomon, and the cloak of the company was a merry shame and fraud. It was held by Lord Macnaghten. The company is at law a different person altogether from the subscribers to the memorandum, and thus it may be that after incorporation the business is precisely the same as it was before, and the same person are managers, and the same hands receive the profits. The company is not in the law the agent of the subscribers or trustees for them, nor are the subscribers as members liable in any shape or form, except to the extent and in the manner provided by the Act. Thus, this case clearly established that company has its own existence, and as a result, a shareholder cannot be held liable for the acts of the company, even if he holds virtually the entire share capital. The whole law of corporation is, in fact, based on this theory of separate corporate entity. Now, the question may arise whether this veil of corporate personality can even be lifted or pierced. Before going into this question, one should first try to understand the meaning of the phrase lifting the veil. It means looking behind the company as a legal person, that is, disregarding the corporate entity and paying regard instead to the reliabilities behind the legal facade, where the courts ignore the company and concern themselves directly with the members or managers. The, the corporate BL may be said to have been lifted only in appropriate circumstances. The courts are willing to lift the corporate BL, and that too when the questions of control are involved rather than merely a question of ownership. Lifting of corporate BL. The following are the cases where company law disregards the principle of corporate personality or the principle that the company is a legal entity distinct and separate from its shareholders or members. To determine the character of the company, that is, to find out whether co-enemy or co-friend in the law relating to trading with the enemy, where the test of control is adopted. The leading case in this point is Daimler Co. Limited versus Continental Tire and Rubber Co. If the public interest is not likely to be in jeopardy, the court may not be willing to crack the corporate shell, but it may rent the wheel for ascertaining whether a company is an enemy company. It is true that, unlike a natural person, a company does not have mind or conscience. Therefore, it cannot be a friend or foe. It may, however, be characterized as an enemy company if its affairs are under the control of people of an enemy country. For this purpose, the court may examine the character of the persons who are really at the helm of affairs of the company. To protect revenues tax in certain matters concerning the law of taxes, duties, and stamps, particularly where question of the controlling interest is in issue, as Brandstein Limited versus Commissioner of Inland Revenue, where corporate entity is used to evade or circumvent tax. The court can disregard the corporate entity Jubilee Lal versus Commissioner of Income Tax AIRSC. In Dinso Manikji Packet, it was held that the company was not a genius company, at all but merely the assessee himself disguised under the legal entity of a limited company. The SEC earned huge income by way of dividends and interest. So he opened some companies and purchased their shares in exchange of his income by way of dividend and interest. This income was transferred back to SEC by way of loan. The court decided that the private companies were a same and the corporate bill was lifted to decide the real owner of the income. To avoid a legal obligation where it was found that the sole purpose for the formation of the company was to use it as a device to reduce the amount to be paid by way of bonus to workmen. The Supreme Court upheld the rising fees rising of the will to look at the real transaction. The workmen employed in Associated Rubber Industries Limited, Bhavna Nagar versus the Associated Rubber Industries Limited, Bhavna Nagar and another. Workmen of Association Rubber Industry Limited versus Associated Rubber Industry Limited. The facts of the case are that A Limited purchased shares of B Limited by investing a sum of 4,50,000 rupees. The dividend in respect of these shares was shown in the profit and loss account of the company. Year after year, it was taken into account for the purpose of calculating the bonus payable to workmen of the company. Sometime in 1968, the company transferred the shares of B Limited to C Limited, a subsidiary wholly owned by it. Thus, the dividend income did not find place in the profit and loss account of A Limited, with the result that the surplus available for the purpose for payment of bonus to the workmen got reduced. Here, a company created a subsidiary and transferred to it its investment holding in a bid to reduce its liability to pay bonus to its workers. Thus, the Supreme Court brushed aside the separate existence of the subsidiary company. The new company so formed had no assets of its own except those transferred to it by the principal company, with no business or income of its own except receiving dividends from shares transferred to it by the principal company and serving no purpose except to reduce the gross profit of the principal company so as to reduce the amount paid as bonus to workmen. Formation of subsidiaries to act as agents. A company may sometimes be regarded as an agent or trustee of its members or of another company and may therefore be deemed to have lost its individuality in favor of its principal. Here the principal will be held liable for the acts of that company. In case of merchandise transport limited versus British Transport Commission 1982, a transport company wanted to obtain licenses for its vehicles but could not do so if applied in its own name. It therefore formed a subsidiary company and the application for license was made in the name of the subsidiary. The vehicle were do the vehicles were to be transferred to the subsidiary company held the parent and the subsidiary were one commercial unit and the application for licenses was rejected. Company formed for fraud or improper conduct or to defeat law, where the device of incorporation is adopted for some illegal or improper purpose, example, to defeat or circumvent law, to defraud creditors or to avoid legal obligations. Guilford Motors Co. versus Horney. Corporate will be listed. Trading with enemy, where corporate entity is used to evade or circumvent tax, where companies form other companies as their subsidiaries to act as their agent to avoid a legal obligation, where the device of incorporation is adopted for some illegal or improper purpose. Classes of companies under the Act, the growth of the economy and increase in the complexity of business operations in the corporate world has led to the emergence of different forms of corporate organizations. To regulate them, the Companies Act 2013 has broadly classified the companies into various classes. A company may be incorporated as a one-person company, private company, or a public company, depending upon the number of members joining it. Again, it may either be an unlimited company or may be limited by shares or by guarantee or by both. On the basis of control, companies can be classified as associate company, holding company, and subsidiary company. Some other forms of classification of companies are foreign company, government company, small company, dormant company, nidhi company, and company formed for charitable objects. Company may classified into various classes on the following basis. On the basis of liability. Company limited by shares. Section 2 subsection 22 of the Companies Act 2013 defines that when the liability of the members of a company is limited by its memorandum of association to the account, if any, unpaid on the shares held by them. It is known as a company limited by shares. It thus implies that for meeting the debts of the company, the shareholder may be called upon to contribute only to extent of the amount which remains unpaid on his shareholdings. His separate property cannot be encom- encompassed to meet the company's debt. It may be worthwhile to know that thus a shareholder is a co-owner of the company. He is not a co-owner of the company's assets. The ownership of the assets remains with the company because of its nature as a legal person. The extent of the rights and duties of a shareholder as co-owner is measured by his shareholdings. Company limited by guarantee. Section 2, subsection 21 of the Companies Act 2013 defines it as the company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake by the memorandum to contribute to the assets of the company in the event of its being bound up. Thus, the liability of the member of a guarantee company is limited up to stipulated sum mentioned in the memorandum. Members cannot be called upon to contribute beyond that stipulated sum. The common features between a guarantee company and the company having share capital are legally personality and limited liability. In the latter case, the member's liability is limited by the amount remaining unpaid on the share, which each member holds. Both of them have to state in their memorandum that the members liability is limited. However, the point of distinct between these two types of companies is that in the former case, the members may be called upon to discharge their liability only after common commencement of the bind up and only subject to certain conditions, but in the latter case they may be called upon to do so at any time, either during the company's lifetime or during its winding up. It is clear from the definition of the guarantee company that it does not raise its initial working funds from its members. Therefore, such a company may be useful only where no working funds are needed or where these funds can be held from other sources like endowment fees, charges, donations, etc. In Narendra Kumar Agrawal versus Saroj Malu, the Supreme Court has laid down that the right of a guarantee company to refuse to accept the transfer by a member of his interest in the company is on a different floating than that of a company limited by shares. The membership of a guarantee company may carry privileges yes, yes, much different from those of ordinary shareholders. Unlimited company. Section 2, subsection 20, subsection 92 of the Companies Act 2013 defines unlimited company as a company not having any limit on the liability of its members. In such a company, the company of a member cases when he cases to be a member, the liability of each member extends to the whole amount of the company's debts and liabilities, but he will be entitled to claim contribution from other members. In case the company has share capital, the article of association must state the amount of share capital and the amount of each share. So long as the company is a going concern, the liability on the shares is the only liability which can be enforced by the company. The creditors can institute proceedings for bind up of the company for their claims. The official liquidator may call the members for their contribution towards the liabilities and debts of the company, which can be unlimited. Unlimited company. No limit on the liability of members. The liability cases on when he cases to be member. Liability is not unlimited till the time company is not wound up. Members can be called to contribute only in the event of winding up of company. Liability of each member extends to amount of company's debt and liabilities. However, he can claim contribution from other members on the basis of members one person company. The Companies Act 2013 introduced a new class of companies which can be incorporated by a single person. Section 2 subsection 62 of the Companies Act 2013 defines one person company. OPC has a company which has only one person has a member. One person company has been introduced to encourage entrepreneurship and corporationization of business. OPC differs from sole proprietary concern in an aspect that OPC is a separate legal entity with a limited liability of the member, whereas in the case of sole proprietary, the liability of owner is not restricted and it extends to the owner's entire assets, consulting of official and personal. The procedural requirements of an OPC are simplified through exceptions provided under the Act in comparison to the other forms of companies. According to Section 3, subsection 1, clause C of the Companies Act 2013, OPC is a private limited company with the minimum paid up share capital has may be prescribed at and having one member. OPC, one person company. Significant points: only one person has member. Minimum paid up capital, no limit prescribed. The memorandum of OPC shall indicate the name of the other person who shall, in the event of the subscriber's death or his incapacity to contract, become the member of the company. The other person whose name is given in the memorandum shall give his prior written consent in prescribed form, and the same shall be filed with registrar of companies at the time of incorporation of the company, along with its e-memorandum and e-articles. Such other person may be given the right to withdraw his consent. The member of OPC may at any time change the name of such other person by giving notice to the company, and the company shall in intimate the same to the registrar. Any such change in the name of the person shall not be deemed to be an alteration of the memorandum. Only a natural person who is an Indian citizen were resident in India or otherwise and has stayed in India for a period of not less than 120 days during the immediately preceding financial year shall be eligible to incorporate a OPC, shall be a nominee for the sole member of a OPC. No person shall be eligible to incorporate more than one OPC or become nominee in more than one such company. No minor shall become member or nominee of the OPC or can hold share with beneficial interest. Such company cannot be incorporated or converted into a company under Section 8 of the Company. Thus, it may be converted to private or public companies in certain cases. Such company cannot carry out non-banking financial investment activities, including investment in securities of any body corporate. Here, the member can be the sole member and director. OPC, one member company, private company in nature, encourage entrepreneurship and corporation of business. Procedural requirements are simplified through exceptions, separate legal entity, limited liability. Private company, Section 2, Subsection 68. Private company means a company having a minimum paid up shares capital has may be prescribed and which by its articles restricts the right to transfer its shares except in case of one person company limits the number of its members to 200 provided that where two or more persons hold one or more shares in a company jointly, they shall, for the purposes of this clause, be treated as a single member, provided further that a person who are in the employment of the company and persons who having been formerly in the employment of the company were members of the company while in that employment and have continued to be members after the employment ceased shall not be included in the number of members and prohibits any invitation to the public to subscribe for any securities of the company. Private company, significant funds, no minimum paid up capital requirement, minimum number of members 2, except if private company is an OPC, where it will be 1. Maximum number of members 200, excluding present employee, cum members and irrestricted will, while employees cum members right to transfer shares restricted. Prohibition prohibition on invitation to subscribe to securities of the company. A small company is a private company. OPC can be formed only as a private company. A small company given under Section 2, Subsection 85 of the Companies Act 2013, which means a company other than a public company paid up share capital of which does not exceed 50 lakh rupees or such higher amounts as may be prescribed, which shall not be more than 10 crore rupees, and turnover of which has per profit and loss account for the immediately preceding financial year does not exceed 2 crore rupees or such a higher amount as may be prescribed, which shall not be more than 100 crore rupees. Exception: this clause shall not apply to a holding company or a subsidiary company, a company registered under Section 8, or a company or body corporate governed by any special act. For the purposes of subclause 1 and subclause 2 of the clause 85 of Section 2 of the Act, paid up capital and turnover of the small company shall not exceed rupees 4 crores and rupees 40 crores respectively. Companies specification of definition details. Amendment rules. Companies Amendment Rules 2022, which WEF 15 September 2022. A small company. Significant points. A private company. Paid up capital not more than 50 lakh rupees or turnover not more than 2 crore rupees. Should not be Section 8 company, holding or a subsidiary company. Public company. Section 2, subsection 71. A public company means a company which is not a private company and has a minimum paid up share capital has been prescribed, provided that a company which a subsidiary of a company not being a private company shall be deemed to be public company for the purposes of this act, even where such subsidiary company continues to be a private company in its articles. Public company. Significant points. It is not a private company. Articles do not have the restricting clauses. Shares freely transferable. No minimum paid up capital requirement. Minimum number of members 7. Maximum numbers of members no limit. Subsidiary of a public company is deemed to be a public company according to Section 3, Subsection 1, Clause A. A company may be formed for any lawful purpose by 7 or more persons, where the company to be formed is to be a public company.